Okay, good evening. This is The Secret, How to Fight CPS and Win. I'm attorney Vince Davis, and tonight is Ask Vince Questions night. So post your questions in the comments section, and we'll try to answer those questions for you today or this evening. And by the way, happy holidays to everyone. Everyone, go ahead and check out this site, suecps.info. All right, let me play a couple while I'm waiting for people to log on and talk to me about their questions. Let me play a couple YouTube shorts that I did. As you know, I'm a lawyer licensed here in California, and we are experts in doing CPS cases. I got a call the other day from a potential client, and he wanted to know what I thought was the most important thing you have to know in winning your CPS case. You know, I thought about it and thought about it. There's so many things you have to know. The law, the procedure, the evidence, the strategy, the this, the that. I mean, there's so many things going on in your head about these cases. But I came down to one thing that I think is probably the most important thing, and that is evidence and the rules of evidence in your particular state. You have to know how to get evidence before the judge so that the judge could see your side of the case and rule in your favor. Call me if you have any further questions. As you know, I'm a lawyer licensed here in. Okay, the topic of minors testifying in CPS cases is always an important topic. These are the things that you must consider. Number one, is the minor competent? In order to testify in California, the minor has to reach a certain level of competency, usually in the ability to tell the truth and to discern truth from falsity or truth from, for example, daydreams or night dreams. Sometimes I've had minors testify that say, oh, they dreamt something, and that's maybe not going to allow them to be competent to testify in a trial or in a hearing. The other thing they have to do is they have to be able to understand the difference and the consequences in taking the oath, the promise to tell the truth, the whole truth, and nothing but the truth. You'd be surprised a lot of minors don't understand that particular consequence. So call me if you have questions. So you have a hearing pursuant to 366.26 in California to terminate your parental rights. There's probably a similar statute in your state as well, where they have proceedings to terminate your parental rights if you have a CPS case. It's important to start planning for the defense of that type of hearing at the very beginning of the case, even when you still have reunification services or you have the chance to get the child or the children back in your custody. One of the things that you should do early on in the case, and at least after your rights of your parental reunification services have been terminated, is ask for a bonding study. Ask the court to get a bonding study between you and your children. Now, to make sure that you do well in that bonding study, you need to visit the children a lot of time while they're out of your care and custody so that there will be a bond. Call me if you have any questions. Okay, good evening. I'm attorney Vince Davis, and we're on the Friday before Christmas, and I'm going to be answering questions from the audience today. So if any of you folks watching, post your comments and your questions. While I'm waiting for your comments and questions, I'd like to discuss a couple of issues that are coming up in cases that I'm working on myself. And it comes down to what I call trial preparation. All right. In order for you to win a case in juvenile dependency court, you're going to have to prepare for it. You're going to have to do some research. You're going to have to do probably some investigation. So these are the facts of this particular case that I'm working on and going to trial on. There's a 16-year-old boy who made allegations that his mother was physically abusing him. And the mother contends that this was done because the boy wants to leave the home, doesn't want to follow the rules, and was placed with a relative who is allowing the boy to do basically whatever he wants. Now, a lot of people tell me, if you go to trial, you're going to lose. And you're going to lose because the judge is going to automatically believe the child. There are a lot of people that believe that, but I don't think they probably have a lot of actual trial experience in juvenile dependency court. Let me give you an example. This happened years ago, and maybe 2 decades ago. I was representing a man who happened to be a member of a gang, and he was accused both in the criminal court and in the juvenile court to sexually abusing his child. And he kept telling me that, you know, it didn't happen, that it was all a made up lie. And he demanded that we have a trial. So I decided, well, I have nothing to lose. We might as well take this to trial and just see what happens. The worst case scenario that would happen is the child would get on the stand and say, yeah, my father, touched me in a way or sexually molested me, not using those words, but using those descriptions. So it came time, the first witness that got put on the stand was the social worker. And the social worker testified to everything that the child had told her during an interview. Now, during the questioning of the social worker on cross examination by me, I noticed that the social worker was using words that the child said that may have been outside the vocabulary of the child. For example, sexual molested me is not a term, a 6 or 7 year old would probably use. So I started wondering, what was going on in this case. And I got the feeling from talking to the social worker that when the social worker was interviewing the child, the maternal grandmother was there listening to the interview. I wasn't there, but I assumed that maybe the maternal grandmother was coaching or answering questions for the child. The problem is that if we put the child on the stand in the judge's chambers, there's no one around to help the child, right? So we put the child on the stand. Someone makes a motion to have the child's testimony taken inside the judge's chambers, outside everyone in the courtroom. So the only people that were there were the attorneys, the court reporter, and the judge, and of course the child. Well, the county counsel in the case took the child on what's called direct examination, and the child, testified magnificently. It was almost like a slam dunk case against my client. Well, one of the things of this story is that I didn't tell you is that the maternal grandmother is actually a deputy sheriff. And apparently she was a high ranking deputy sheriff. The mother of the child was nowhere around. Allegedly, she was a drug user and basically out on the streets. My guy, it was no dispute, was a gang member, and the maternal grandmother blamed my guy for getting the mother on drugs. Now I don't know if that's true or not true, or what the extent of that. And apparently, as we find out later in the story, she was going to do everything she could to keep the child in her custody and not give the child to the father. So when it came time for my cross examination of the child, one of the first things you got to do with a child witness, and really any witness, is establish some type of relationship, some type of positive relationship. Because, psychologically speaking, witnesses have their barrier up, their guard. And what you have to do initially is bring that guard down slowly so that that person, that child, will tell you the truth. And in my opinion, it's easier to do with a child than with, say, an adult or a teenager. So I began my cross examination questions, and I knew in my heart of hearts that this girl had been coached. And I took a big gamble. And I said to the girl, I said, "Is there anyone else in this room who has touched you in your private parts?" Pointing down to her vaginal area. And she looked around as if to look for some kind of assurance or guidance, but there was nobody to give it to. There was no social worker. There was no grandmother. Although the child's attorney was there and kept objection, the judge, to the judge's credit, told the attorney basically, your objections are overruled. I want to hear the answer to this question. So the girl looks around and she pauses. Now I represent her father, and she's accusing her father of sexual abuse. So one of the things that I did, I kept trying to develop that relationship and kept giving her reassurance. So at some point when she is hesitant and doesn't know what to say, I say to her in a very tonal voice, "Hey, you know, you can trust us, everyone here. Nobody will know what you tell us here today," which wasn't true, right? And I got a lot of objections, but the judge let her answer the question. And the question was, "Is there anyone else in this room that touched you?" To my shock and surprise, and everybody's in the room shock and surprise, the girl turns to the judge. Girl sitting here, and she turns to her left, right? And she's looking at the judge and she says, "He touched me." And she points right at the judge. Now, she has just identified the judge as a perpetrator of sexual abuse against her. And then, before anybody could say something and object or give her some kind of clue, I said to her, "And that man right there, who was one of the other attorneys, he touched you too, didn't he?" And she said, "Yes, he did." And let's be honest and tell everybody the truth. I touched you too, didn't I? And she said, "Yes, yes, you did." Now, suffice it to say that after my questioning, the judge stopped the trial and asked the county counsel, the prosecutor, if she wanted to continue. And to her credit, the county counsel said, "No, Judge, I don't want to continue." And the judge made a ruling in my client's favor. Now, here's the interesting thing, that testimony was then given to my client's public defender, because remember, he had a criminal case against him, and the case was dismissed. But there's another part of the testimony, the girl's testimony, because at some point, the judge allows me to question the child. And the child admits that her grandmother, the sheriff, high ranking sheriff deputy, told her to say that the judge touched her, that the other male attorney touched her, and that I touched her. And more importantly, that the grandmother told her to tell everyone that the father touched her. So, when people tell you don't go to trial because it's a waste of time, you know, I can see how people say that. Okay? I can see that. But it's not necessarily true. And a lot of times people say that because they don't have the experience that I had with a witness. When you get on a witness on the stand, you're going to be shocked sometimes at what they say. And a lot of times, what they testify to is not what the social worker wrote in the report. And that's with any witness, not just a child witness. You know, um, there was another case that I did. I represented a mom, and the mom kept telling me that what the social worker wrote was not accurate. And this is what the social worker wrote in all the reports. I spoke to the minor's therapist, which the minor had a therapist before the juvenile case started. And the therapist said, basically, I'm not going to quote it, but basically the report said the therapist said that the mother was emotionally abusing the child and the child should not be placed there. I put the therapist on the stand and not the therapist, I put the social worker on the stand and I cross examined her. And she told us the when, where, how, and how she had this conversation with the minor's therapist. And it was written in two different reports. Well, what she didn't know, and I guess she thought, you know, nobody would ever do this. What she didn't know was I found out. I spoke to the therapist. My client put me in contact with the former therapist of the child. And I asked the therapist, I said, "Hey, did you ever have this conversation with the social worker that," and before I could say anything, she says, "Hold on, let me stop you right there." She says, "I've never talked to a social worker." I said, "You've never talked to any social worker?" She said, "No, I've never talked to a social worker from the county." I said, "You didn't do it on the phone?" She said, "No." "Not in person?" "No." "Not via email?" "No." I'm telling you, Mr. Davis, I've never met or talked to a social worker at all, and including on this case. I put the therapist on the stand. She was sitting outside. Nobody knew who she was, and I kept, reassuring her during the day that she'll be called in a few minutes. And I put her on the stand and I got that testimony from her. And she said, "I've never talked to the social worker. I never said that to any social worker." Now, was that a mistake by the social worker? Was it false reporting by the social worker? Was it an outright lie by the social worker? You never know until you go to trial. I talk to a lot of attorneys in this area of practice, and what a lot of attorneys do is they read the social workers' reports and they accept those social workers' reports as being gospel, as being true. And it's not true. Not true. So the only way that you're ever going to bring that out is in trial under oath. Now, here's what a lot of people think you can do, that you can go to trial, not call any witnesses, and have your attorney represent to the judge in oral argument, that what the social worker said about ABC that is false. Well, that's a recipe for a loss. That's a recipe for a disaster. Because if the social worker's report, which is now in evidence, says ABC, and you don't present any evidence to contradict that, the judge is supposed to find the social worker's report accurate and credible. Therefore, you lose. The only way you can challenge that report is to bring in a witness that says something different from the social worker, or to put you on the witness stand to say that something is different, or to put the child right on the stand, or that one of the other, the father, somebody, some witnesses, and the more the merrier, has to contradict the social worker's report. Your appellate cases in California have said this repeatedly. Attorney arguments and representations are not evidence. So if you go to trial and you don't put on a witness or two or three or four or five, and your attorney gets up there and argues and you lose, it's not corruption. It's not the judge being a bad judge. It's you didn't put on any evidence to contradict the social worker's report. So when you're going to trial, make sure that you and your attorney plan a strategy. The first thing that I think you should do is you should meet with your attorney by phone. In person is better, right? And discuss what the overall strategy is. Now, before you do this, and a lot of attorneys don't ask for this, I do. You should go through the report that the social worker has written. Sometimes there's one or two or more reports and addendums. and go line by line and tell the attorney on a piece of paper what's not true and what is true. Let me give you an example. On page 3, paragraph 2, second sentence says, the sky is blue. Now, if that's not a true fact, you have to tell your attorney because your attorney wasn't there on that day. He doesn't know what color the sky was that day. It could have been black, could have been gray, right? Could have been white because it was just clouds. So you have to tell your attorney. And what I would do is I would get a separate piece of paper, write page 3, paragraph 2, second sentence, where it says the sky is blue. That wasn't true. On the day of the incident, the sky was black. It was about the thunderstorm. Okay? You have to provide that list to your attorney of all of the things. And what I also ask people to do is, hey, once you tell me what's not true, is there anybody, including yourself, that could testify, that could actually get on the stand and testify to what color the sky was that day? Right? Oh, yeah, I can testify to it. The kid was there. My mother was there. My next door neighbor was there. And your witness list starts to grow. There's no shame in having witnesses at your trials and CPS cases. I know that a lot of attorneys, excuse me, a lot of people frown on bringing, witnesses to trial. And a lot of times, I get people laughing at me, chuckling at me that I have a witness list of 10 people. Most trials that I see in CPS courts, there's no witnesses, right? They may call one or two witnesses. But if you go through that report, there's many witnesses that you can bring in to show that the social worker was incorrect on an important fact or a collateral fact or something that was said or not said, right? So you got to have witnesses. The other thing you got to do is you got to subpoena those witnesses to court. You got to have fill out a subpoena. Your attorney has to fill out a subpoena, and your attorney has to have them served. Now, luckily in California, the sheriffs will serve your subpoenas for CPS cases um, for free. You don't have to pay for them. All right. I think that's by statute in the government code. But subpoena witnesses to court. I mean, it always gives you an advantage. Always gives you an advantage. All right. The next thing you got to do is you got to come up with a list of exhibits, pieces of paper, pictures, videos. They're all called exhibits that you can use to show the judge that something is not true or that something is true or false. I once did a case in Los Angeles where we had a video of the father entering the house at night and the father leaving the home at 6 o'clock in the morning to go to work. And it was taken by a private investigator who was hired to watch the father go into the house and leave from the house that next morning. Here was the problem. The problem was he was court ordered not to be in the house. And the house belonged to his parents, who said on many, many occasions that their son didn't live there. Well, there it was. Father coming home at night on video, father leaving in the next morning, going to work. There was the private investigator who was there who could testify as to what happened. So they got caught. Good evening, Miss G. How are you?
I'm good. How are you?
Good. So you want to make sure you have your documents, your exhibits, and your witnesses lined up, right? A lot of people want to talk about the law, all right? The law is important, don't get me wrong, but the story and the facts are more important than the law, in my humble opinion. And I've been doing this over 30 years. Ms. G, I'm going to go back and look at some of these questions. Was there anything that you wanted to share with us this evening?
No.
Okay. Here we have Erica Perez. Erica Perez says, can we talk? Sure. Just, if you don't want to do it here, you can give us a call. Bottom right hand of the screen, 888-888-6582. You can call anytime and ask for Miss G or myself. All right.
Can you just give them the email address to email me, please?
I'll tell you what, I'll post it in the comments.
Mm-hmm.
GAT@VincentWDavis.com. Okay, so it's posted, Eric. You can catch that in the comments. Okay, go ahead.
It's okay. Go ahead, read the question, and I'll go after.
Okay, Armando says, I'm going to trial on June 5th, and the caseworker, the light of the piece of paper, and now they're telling my kids they got rights. Okay, Armando, I'm not sure about that question. Do you know have any idea what he means, Miss G?
I'm going to trial on June 5th, and the caseworker, the light on the piece, lied. He probably said lied on the piece of paper. He probably meant to say that.
And then he says they lied on the piece of paper. Okay,
Yeah.
so that's strange. Okay, well, the only way you're going to be able to prove that, Armando, is by going to trial and having witnesses testify, just like I just mentioned in your trial preparation with your attorney. Okay, Chad says this is not a question on this topic, but when is CPS becoming harassing? And also, can you ever find out who falsely accused you of these allegations? Well, you can find out, and it's done through discovery. All right. A lot of times, CPS tries to hide behind the confidentiality shield. But if someone comes in and says, "Hey, I saw Vince rob the bank," that person has to be brought in because I want to cross-examine them to test their demeanor and their credibility, their veracity. So, don't let the social worker and the social worker's attorney hide behind the confidentiality shield, because, in my opinion, the due process shield and sword is stronger than the confidentiality. But it's on a case by case basis, and it will be the judge who will make that decision with your lawyers and your legal arguments and factual arguments. Armando says the first excuse department made that I knew my ex-wife's living conditions where my kids were staying, that was false. I called the department many times. Well, Armando, you need to get subpoena copies of those telephone calls and telephone records to show that you are making complaints. All right. Then Armando says, second excuse, department made use against my criminal history back in 2000. They said I was a drug addict, so I took my police report to the department. It was dismissed. Okay. Now, if you have to go to trial, Armando, you got to bring that police report into evidence. You have to subpoena it, and you're probably going to have to subpoena the officer or the custodian of records for the police department to say that is true and correct copy of the report or of the criminal history with the case being dismissed. It was dismissed, but it's not evidence until you get it properly admitted into court. So don't assume that just because it really happened that the judge has to admit it into court and accept it as being the truth. Armando, third, because all those didn't work because I have paperwork that they were lying. Now they're saying I'm abusive. Well, the longer you're involved with them, the more and more allegations they're going to come up with, Armando. So don't be outraged. Just know that that's going to happen. Now, if that didn't work, the paperwork you have didn't work. See, Miss G, this is what we were talking about a couple nights ago. He has the paperwork, but it's not working for him in court. You know why? Because it's not admissible evidence. He and his lawyer haven't figured that out. Armando, I have paperwork. I called them. I have paperwork on my criminal history, and everything that I said about me was a lie. All right, Armando, I understand that. You have the paperwork. Now, I hate to tell you this, but that's a big so what. It's not admissible evidence, Armando. Even if it's true, you have to talk to your attorney about how to make that admissible evidence. You might have to subpoena in some witnesses, custodian of records, the police officer who wrote the report, blah, 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 blah. You get it? Ms. G, you see what I'm saying?
Mhm.
He's got paperwork and he's still losing because it's not admissible evidence. Go ahead. You had your hand raised.
If I just need to speak to the public out there about retainers and stuff. I had a very disturbing call the other day, and the couple thought Attorney Davis can go to out of state for them and handle two cases and take the money from the settlement. It was two cases, and I told her and her husband that he's not going to do that. He needs to get, you know, the retainer amount in order for him to start the case, in order for him to travel there and get everything done that he needs to do. However, I was told that that person watches our show, and Mr. Davis should have the decency, basically, in other words, to take on the case and wait for the money to settle. Now, remember, there's two different cases. We're talking about CPS, we're talking about civil. Now, nothing settled yet, but they literally said that Davis does all these shows. We do all these shows and to help people. Yes, we help people, but we're not nonprofit organization. We don't get donations, right, for cases, and we don't get paid by the state. So when you're calling a private firm, don't expect to get services because you're special for free or nothing at all down, because the attorney has to spend money to work on your case. Everyone think their cases are different. We get it. But you're not special because everyone is special. Everyone needs help.
You,
But oftentimes, no, let me finish, Mr. Davis, because you really got to me yesterday, and I was really upset about that. But they made Davis look like he's that he's doing this just to get um recognition. Mr. Davis has already gotten recognition. He doesn't need the shows to give him that. We do the shows to give you guys free legal advice and to be able to guide you guys to your situation. He's doing it for free. So let me make that very clear. See, people, either you're serious about your case or you're not. We're not here to play games. I'm not here to play games. I don't have time for this. Bottom line is, we get paid for services like every other attorney. The other day, I went for a hair consultation. The lady said, I want $150. I almost had a heart attack. So just because we charge for services, don't say that we don't have a heart. That really got to me. Oh, I have a heart. Mr. Davis has a heart. You know why I have a heart? Because I worked until 2:25 in the morning last night. And I emailed Davis as well and other receptionists in the office. So yes, I do have a heart. You know why? Because I do this on my own time to help you guys. So I don't need the BS crap talk. That's all I have to say.
all right. So I want to tell you
It's ridiculous.
why a lot of people feel the way they do. I've been doing this 36 years this December. Actually, it's December. I've been doing this 36 years because I think I was sworn in 36 years ago, like December 5th or something. But car accident cases. Miss G, if you get in a car accident right now, you'll probably hire an attorney, and he or she will agree to take 1/3 of your whatever you get as his or her fees in the case. Now, notice the attorney that you hire is probably going to be, within a 5-mile radius of you. Okay? So everyone thinks that that's how attorneys should be doing cases.
Mhm.
Now, that model is only a model for car accident cases, but people are picking up that model and saying, hey, on my CPS case, you should do the same thing.
Mhm.
And here's what I get a lot. I get a lot.
Pay me when the case settles. What are you talking about when the case settles?
This happened today. Lady from Florida calls me. CPS is screwing her over. She's not getting her kids back. And she wants me to come out there to Florida to fight the case and get her kids back. Then she wants me to sue them for civil rights violations, right? And then if we win or settle the case, she wants me to take my fees out of that settlement. Sounds reasonable, right? Let me tell you the problems with that. Number one, I'm in California, Los Angeles County. I'm not down the street and around the block from her court in
Mhm.
Florida. Now, how am I supposed to get to Florida? Jet, round trip, food, hotel, Uber, taxi,
Mhm.
car rental, whatever. Who's going to pay for that? Who's going to put up the real money to pay for that? Oh, you will, Mr. Davis. No, Mr. Davis can't afford to do that to finance your case, right? Well, why can't you take it out of the settlement?
Mm.
Well, here's number one. The settlement, if you win, is probably 3 years away, 2 to 3 years away. Mr.
Mhm.
Davis doesn't have the money to put up and wait for your case to settle. This
Mhm.
isn't a car accident case.
Mm-mm.
And I'm not down the street and around the corner from your house or your court. I'm in California.
But wait, there's more though. Actually, the best part is when they say, "I have a winning case." We haven't even looked at the paperwork, but all of the sudden, oh, believe me, we have a winning case. No, I'm not gonna believe you because what's written down needs to be addressed. It needs to be looked at. You can't go to a doctor's office and say, "I have the flu." The doctor's gonna say, "Well, we're gonna have to do a blood test." Bottom line, to know what's really going on. The doctor's not going to sit here and say, "You know what, Georgette, you have the flu because you said you have the flu." It doesn't work that way.
Right.
I mean,
No.
I have so many calls, you guys, a day. I don't have time to play around. Either you want your kids, we did not get you in that situation. We didn't get you there. Please understand that. So taking it out on me is not going to help you. I'm trying to help you, but you have to be able to communicate without saying anything derogatory against me because I mentioned a retainer. If you're not happy about a retainer, then why are you calling a private firm? That's my question. If you want to come and work for me for free for 2 to 3 years, please let me know. And that's basically something for you guys to think about.
Okay. So just think about it. It costs money to go to Florida to get the kids home, right? And it costs money to try to sue the social workers. Here's one thing that a lot of people don't realize, and when I tell them this, they're kind of shocked. Did you know, Miss G, that social workers in most states, and definitely in California, have something called qualified immunity?
Yes.
Okay. That means you can't sue a social worker and win for just mere negligence,
Mm-hmm.
mere stupidity. Okay?
Mm-hmm.
You actually have to prove that the social worker did something intentionally with malice, fraud. Now, here's one of the things that is malice or fraud. Social worker lies under penalty of perjury. That's malice. That's fraud, right? Social worker not calling you back unless you can prove that it was malice or fraud. That's just mere stupidity or
Mm-hmm.
negligence. You can't win a case for social worker negligence in
Mm-hmm.
California, probably most states, because they have qualified immunity. It is hard to sue someone with qualified immunity and win.
Mm-hmm.
It's hard.
People don't know the law, Davis, and they think they know. And when I try to educate them, they don't want to hear it. They think they're right. They don't want to listen for anything. And that's the problem. The problem is it's not about suing the social worker right now. Why don't you focus on getting your children back first?
Yeah, we do a whole nother show. Have a whole nother show on suing the social workers.
Mm-hmm.
It's completely different. All right. Brian says qualified immunity is such BS. I agree. It
Yep.
just happens to be the law. I don't make the laws. I'm the guy you come to try to get what you want in spite of the laws.
Mm-hmm.
The qualified immunity of social workers is real. Okay? It's real. So don't tell me you have a winning case unless you give me a legal analysis of qualified immunity in the federal court system.
Mm-hmm.
All right. Now, this is a really good suggestion.
I've been saying that for years, Davis.
That is a really good suggestion. Just like police, it, I don't know if you remember this, I'm an older guy. There was a time police didn't wear cameras, body cameras. There was a time where they fought having to wear body cameras. The years have gone by. Now they have to wear body cameras. And they're trying to deal with the fact that sometimes the body camera is turned off. Right? What are we going to do about that? Yes, I agree social workers should be made to wear cameras so that everything is audio and videotaped. Because sometimes they're mistaken, or worst case scenario, they're not telling the truth.
Nope. None of them.
So, let's consider that. That's one of the things that you can vote in for some type of law, Miss G.
It's unfortunate, but oftentimes I get calls with people that are near their termination of parental rights. They want us to, I mean, the whole conversation is about the retainer, right? And they don't want to pay it, but yet they want us to get their children back. But why did you wait that long? I don't understand why people wait that long. I don't get it. Why wait until your termination of parental rights is in 2 weeks or 3 weeks? It makes no sense to me, and I get angry because the children are the ones like suffering, and then they're trying to make me feel guilty because I asked them for a retainer. It's kind of like ridiculous. It's ridiculous.
Unfortunately, everyone's used to the free lawyer that the court gives out. And if you want to go with the free lawyer, go with the free lawyer.
Mm-hmm.
But if you call me, I'm a private lawyer. I charge for my services.
Mm-hmm.
You know, I'm sorry, but I don't feel bad about it. I mean, it's exchanging my knowledge, my time, my expertise to help you win your case.
Exactly. So I'm not understanding this. We're not Bill Gates or anything like that. So maybe if Bill Gates was an attorney, he'll do it for free.
Right. All right, we're coming to the end of the show this evening, Miss G. I told Grace, and I'm still trying to build this out. I want to have a special Christmas show, and I'm trying to line up some people. But our show on the weekends is 9 o'clock, usually 9 to 9:45. But I'm trying to do something special for Christmas because there's so many of our viewers who are involved in CPS and don't have their children with them.
Mm-hmm.
And I can only imagine what it must be like to go through a Christmas without having
Mm-hmm.
your child. So, anyway, Miss G, thank you for joining me this evening. I appreciate it. And I want to thank everybody for watching. Tomorrow, Saturday, 9 o'clock, 9 a.m., and Sunday, Christmas Day, 9 a.m. All right? So, good night, everyone, and let's do this again tomorrow morning.
Good night.